Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to address the pros and cons of the most common ways that you can leave your estate to your spouse. And while we're at it, we'll discuss all of the family dynamics, the taxes, and the long-term protection that's available. So if you're married, it's probably natural to think, if I pass away before my spouse, I think everything that I have should just go to my spouse when I pass away. But that one single decision can have big consequences for taxes, for your kids, and what happens to your legacy. So let me give you an example. Let's say Mark and Martha are married and they have a combined $6 million estate. Let's just say each of them is deemed to own half of the $6 million estate. So Mark owns $3 million and Martha owns $3 million. And while these decisions of how to leave things to the surviving spouse are the same, both for Mark and Martha, let's take a look at this from Mark's perspective. Mark thinks he's going to die first because he's a couple of years older and he's a man. So let's look at this from Mark's perspective. Well, Mark realizes after doing some homework, maybe having conversations, maybe after watching this video, Mark realizes that there are two common but very different ways that Mark can leave his estate to Martha when he dies. One option is outright. Mark dies and he leaves his $3 million to Martha, so that Martha owns the entire $6 million. Or the second option is Mark can leave his estate in trust for Martha, so that after Mark dies, Mark's portion goes into a trust. Let's call that the Mark Trust. Maybe Martha is the trustee of that Mark Trust after Mark dies. Maybe Martha gets the income from the Mark Trust. Maybe distributions of trust assets can be made to Martha under certain circumstances. That all varies by the terms of that Mark Trust instrument. But by Mark leaving his assets in trust after Martha dies instead of outright to Martha, by Mark leaving his assets in trust, the remaining Mark Trust assets must revert back to Mark's children or other of Mark's intended heirs when Martha later dies. All right, so let's go through the pros and cons of outright versus in trust. First, let's talk about the pros and cons of Mark leaving his $3 million, or whatever that amount may be, Mark leaving his portion of the estate outright to Martha. So what are some of the pros? Well, it's really simple. Mark dies, his $3 million estate goes to Martha. Martha owns the entire $6 million estate. That surviving spouse has full control to manage, invest, and spend. And then there's another big pro of leaving things outright to your spouse, and it has to do with the taxes. And as I address these taxes, let's know that we're not really concerned at this point about federal estate tax. For people who pass away in 2025, each spouse has a $13.99 million estate tax exemption. And married couples, as long as they do the planning properly, either by having the documents correctly prepared or by making certain portability or other elections, marital deduction elections after the first spouse dies, married couples these days can really shield $28 million, 13.99 million times 2. Married couples, because each spouse has their own exemption, married couples can shield $28 million from the 40% federal estate tax. Mark and Martha have a combined $6 million estate, so they're not really worried about having to take certain actions to avoid the estate tax because they feel like it's just not going to affect them. But there is a big tax consequence that how they leave things to each other does have a big tax consequence. So the big pro of Mark leaving his estate outright to Martha from a tax perspective is, you see, when Mark dies, his estate, which is $3 million, will get a step up in basis. So, Mark may have had some appreciated stock in his estate, and when Mark dies, all of those assets get a step up in basis. In fact, if Mark and Martha lived in a community property state when Mark died, then all of the community property, not just Mark's half, but Martha's half as well, all of the community property, if they live in a community property state, gets a step up in basis when the first spouse dies. That all's great. But by Mark leaving his $3 million estate, or whatever it is, outright to Martha, That puts all of the $6 million of assets into Martha's estate. And the good news there from a tax perspective is Martha could live another 5, 10, 15, 20 or more years. And those assets are likely to grow from the time Mark dies until the time that Martha dies. So by Mark leaving his estate outright to Martha and including Mark's assets in Martha's estate, again, still well under the $28 million estate tax exemptions, but by Mark leaving his estate outright to Martha, all of the $6 million of assets are included in Martha's estate, and all of those assets will get another step up in basis when Martha dies, eliminating tax on all of the appreciation from the time that Mark dies until the time that Martha dies. That's a big tax advantage for those children or other heirs who will inherit these assets after both spouses pass away. So again, the pro of leaving things outright to your spouse is it's simple, and the surviving spouse, all of the assets are included in the surviving spouse's estate, meaning all of the marital assets get a step up in basis when the surviving spouse dies. Well, what are some of the cons of leaving your estate outright to your spouse? Well, since Mark did leave all of the assets to Martha, they had $6 million, Mark had $3 million, Martha had $3 million. Mark dies. Of course, Martha still continues to own her $3 million, but Mark left Martha his $3 million, so Martha now owns the entire $6 million. Since Mark left all of his assets to Martha, that remarriage risk exists. Or rather, Martha can leave the entire $6 million estate, or whatever it may grow to. She can leave that to whoever she wants. She owns it all, including she can leave it to her next spouse while excluding Mark's children or Mark's other intended heirs. So that's the big con of leaving things outright to your spouse, is your spouse can exclude your intended heirs because your spouse can leave all those assets to whoever they want. All right, so now let's go to what are the pros and cons of Mark leaving his estate in trust for Martha. So if Mark's thinking, I have $3 million, Martha has $3 million, I think I want more protection for my kids in place to receive it after both of us die. So Mark may like the idea of leaving his estate in trust for Martha. If Mark leaves his part of the estate, his $3 million of assets, in trust after he dies, we called it the Mark Trust, then Mark controls the final distribution of his assets. It ensures that Mark's children or his other intended heirs receive what's left of his estate after he and Martha die. So that makes this scenario where a married person leaves things in trust for their spouse, that makes it really common in these blended family situations. You know, if Mark has 2 children and Martha has 3 children, Mark likes the idea of providing for Martha, leaving his estate in trust so that Martha can use that for her needs. But when Martha dies, the remaining Mark Trust assets revert back to Mark's children, preventing, Martha's children from getting the entire estate. So Mark likes the idea of providing that protection for his children or his other intended heirs. Also, if Mark wants to, he could appoint someone other than Martha as the trustee of the Mark Trust to manage assets after Mark dies, if he feels like Martha is not, financially savvy. All right, now let's talk about some of the Mark leaving it in trust. What are some of the cons of that? Well, it's more complex. When Mark dies, there's more ongoing trust administration. When Mark dies, the assets have to be split. Mark's part of the assets goes into the Mark irrevocable trust that Martha can't change, and Martha's assets remain under her total control. So there's more ongoing trust administration required when Mark leaves his assets in trust versus Mark leaving his assets outright to Martha. Also, the big tax con of leaving things in trust for Martha is When Mark dies and leaves his estate in trust for Martha because he wants to give his kids more protection so that they'll receive what's left of those assets when Martha dies, well, those assets, generally speaking, are not going to be included in Martha's estate. And since the Mark trust assets are not included in Martha's estate, then those Mark trust assets will not get another step up in basis when Martha dies, perhaps many years down the road, requiring Mark's heirs to perhaps pay significant capital gains tax when they sell those assets after Martha dies. Okay, so at the end of the day, there really is no one-size-fits-all answer. What matters most is that you become informed and that you align your plan with your goals, your family dynamics, and the legacy that you want to leave behind. But also it's important that you understand those tax consequences so that you can make fully informed decisions. Okay, hope that helps. We'll see you next time.